automatic part shall be retroactive. Section 2 amends KSA 216614. That's the expungement statute to remove references to diversion agreements, since those will be expunged pursuant to this new section of law. And I can take any questions.
Representative Carmichael.
Thank you, Mr. Chairman. Of course, there is the classic question, have we seen this before?
You have. Last year, it was House Bill 2575. This committee heard it. They made some changes to it. It went to the floor, and then it was stricken from the calendar.
It didn't actually reach the floor. It remained below the line, or?
Correct. Yeah, you didn't debate it on the floor.
Right. Thank you. Second question, with your leave, Mr. Chair. Does the legislation extend to biological samples, bodily fluids, DNA profiles, the information that's oftentimes stored on a system known as Codex? It's a national database.
Mr. Chairman,
I don't think it does, but that's why I'm inquiring of you.
Yes, Mr. Chairman, I would have to look at that a little bit more specifically. We do have another statute that talks about destruction of those biological samples, and I can't remember if that's referenced in here, so I'd have to look at that a little bit further.
I can't either, because I know that we've had discussions with the KBI on this topic last year regarding other legislation. I'll try to think as well. Thank you, ma'am.
Representative Humphreys.
Thank you, Mr. Chair. So, Natalie, will you remind me, so going forward, certain records are automatically expunged. Okay, but then, so then the next paragraph in your explanation is ones that haven't been expunged automatically will petition the court.
Right.
So, I mean, can you explain the difference?
So the difference would be that, so if I have a record where I was acquitted or my charges were dismissed, that's not going to be automatically expunged as part of my case because my case is over. So going forward, if that were to happen tomorrow, then these provisions would kick in, the automatic expungement provisions would kick in. But this allows people who have those records already petition the court to get those expunged, since that automatic process doesn't exist right now.
Okay. And then, I mean, if there were charges and they were dismissed or acquitted, but then later, so they petition and then the prosecutor objects. So then there's a hearing and the prosecutor shall notify any victim. So, but who is it? I mean, if someone's acquitted, who's the victim? I mean,
and perhaps it should say the alleged victim, or I think that the reason that was put in there, and you guys had this conversation when you've heard the bill before, is that it applies if the charges are dismissed even without prejudice. So say the charges were dismissed, but the prosecutor intends to refile. That's where they're going to, I assume, use this to come say, hey, we're refiling these charges, so don't expunge the records yet. But you're right. I mean, if the person is acquitted, then technically that person wouldn't be considered a victim. I guess maybe they would still be a victim, but not of that particular instance.
Okay, thank you. Thank you, Mr. Chair.
Any other questions for Natalie? Yes. Representative Titus.
Thank you, Mr. Chairman. Natalie, just from out of curiosity, why do DUIs get excluded from this process?
Mr. Chairman, Representative Titus, DUIs have their own very special set of circumstances when it comes to getting them expunged and for counting priors. And so I believe that's probably why, as a policy matter, they would be excluded. But that's just a policy choice.
So if you have a drug possession, you could get it expunged under this.
A drug possession would fall under these provisions.
Any other questions? Thank you, Natalie. For proponents, first one I have is Marilyn Harp.
Hi, thank you for hearing me today. I also testified last year when the bill was coming up, although I had a different role at that time. I have retired from Kansas Legal Services and am now before you as a citizen lobbyist. So lobbying about things that came out of 43 years of working at Kansas Legal Services, and this is certainly one of them. I'm going to start because some of my conversations with you all led me here to like, okay, how does expungement work and who gets expunged? So I would just call your attention maybe to the third page of my testimony where there's a chart that we use in a lot of public situations that list the cases in the first box that are not eligible for expungement under any circumstances, the cases that have a 3-year wait time, and the cases that have a 5-year wait time. So that will just answer those questions a bit about eligibility for expungement. But then let me say that nothing in this bill changes anything about how or what can be expunged, with the exception of not guilties and not guilties and dismissed cases. Ms. Scott mentioned that this is the bill as you all passed it, but over time we've done a lot of work with this bill to gain the proponent testimony of many people that you might think would be adversaries here. So some of the compromises, some of the questions that were asked, like why is DUI off? Because DUIs are kind of the third rail of all criminal things, and to pull that controversy into this could create a problem. So they are off in part for that reason. Let me just say that I mentioned 40 years of working on things with low-income people. I have found nothing in that time that can make a more profound difference in the economic lives of people than financial expungements, which is why I'm here about that topic. There's some science behind that, some research behind that. The University of Michigan Law School did a study in 2020 and found that in the first year after expungement, people's wages improved 23%. And women and Black recipients of expungements have their wages increase even more than that. Financial stability for their families, for their neighborhoods, are a result of expungement. And yet that same study found that only 6.5% of people who meet the legal requirements for expungement in Michigan actually get one. And I would say from my experience, that is pretty consistent with Kansas. Less than 10% of eligible people go through the process of public sealing of their records because it's an expensive process. $500 to $700 for attorney's fees to do it. It is a difficult process for people to do on their own. And so now I'm going to speak for a minute about the research we've been doing with the Harvard Law School Access to Justice Lab. We enrolled 150 people in the side of the experiment that was looking at self-represented people. We provided them all the information they needed to fill out the form, a template to use to fill out the form, an opportunity to meet with a lawyer and go through that form and the process. And only about 15% of people who expressed an interest in getting an expungement followed through that process as self-represented people, which brings us to the idea of letting the computer system do that work for appropriate people. Those of you who have watched, there was reference to last year's bill, but this really is about a 3-year effort. The first year introduced the idea of prosecutors doing expungements at the end of cases, and that created that there was an issue there. Like prosecutors represent one side of the state, and expungement, as it's currently seen, would represent the defendant, and so that was a problem. We then thought about perhaps judges initiating the process, And again, judges have a different role. And so to initiate that process for a defendant was a problem. This idea brings up the use of technology and lets the computer initiate that process by creating the order in appropriate cases, leaving it only for the prosecutor to object if they want to, and or or uh, or the judge signs off on the form. So it's the computer that's initiating this process, and we don't have to argue about whose side, the defendant who is having trouble accomplishing it on their own, the prosecutor who's on the other side of the case, or the judge whose role is really different. Well, let's leave it to the computer, write some language, let the prosecutors make sure, and of course a lot of testing, but if some case slips through, a prosecutor is looking at it, we're not doing some whole bulk group of orders, which we also learned in the process would run us afoul of the compact that the KBI has signed with NCIC, which prohibits the use of any mass expungement of records. So a lot of thought and looking at competing interests here. And now I want to focus on one thing, which is why not guilties and dismissed cases? Like, what's the deal with that? Well, you can see on my chart that the wait time is how much time since satisfaction of the sentence. And if there's no conviction and there's no satisfaction of a sentence, then uniquely, Kansas law does not clearly allow people who have not guilties or dismissed cases to get an expungement. It's kind of weird because if you go next door to go to surrounding states, not guilties and dismiss are some of the only things in many states and a few states that you can get expunged. But in Kansas, we don't have any clear language to allow that to happen. And so we are closing that hole with this bill and saying, if the prosecutor dismisses a case, if you are found not guilty of something, shouldn't you surely be able to make that record not available to public view? Now, the whole ramifications of public view have changed substantially even since we started this, and other people are going to speak to that issue. But shouldn't sealing, whether it's the individualized process or this or ultimately an automated process, be easier for a finding of not guilty than a finding of guilty? And this bill allows that as well. So the only other thing I'll say is because diversions under law are considered dismissal with prejudice, they would also fall into this case because, the diversion law says complete the terms, then the prosecutor shall dismiss that case with prejudice. So diversions do become dismissed cases under this, as the law sets out for diversion. So I think we're going to have questions after, and I'll be available at that point.
Yes, we're going to have questions after. Way to go, Marilyn. Thanks for reminding me of that. So yeah, we'll work through the list. If you've got questions and you might forget that you want to be on the list, go ahead and wave at me. I'll get you on the list, and then I'll call on you, and hopefully you remember what your question was. Lindsay Ford.
I feel like I need to stand back from these. Hi, I'm Lindsay Ford. I'm with the State Board of Indigent Defense Services Legislative Committee. I, like Marilyn, contributed testimony to this bill last year in a different organizational capacity, but again, find myself here supporting efforts to get this passed. In my new role, I've been able to learn so much more about how criminal records of any kind really impact the lives of the people who have to live with them. And I reference that a lot in my written testimony. Please take a look at that when you get some time. Instead of reiterating all of that and boring you all, I have some stories I'd like to share. In preparing for this, I asked around with some of my coworkers and my public defender office if what they knew about expungement, what their experience with it was. And frankly, there wasn't a lot. And I'll talk about that in a minute. But I had two really great ones. The first one was about a man who had been charged with a very serious crime. It was an off-grid crime. He went all the way through trial. He was acquitted. But more than that, like in talking with the jury afterwards, the jurors were like, it is very obvious this man is innocent. Not like the state failed to meet their burden, but this man clearly did not commit a crime of any kind. And as they were leaving, the judge recommended that the individual pursue an expungement to get the arrest record removed from public view. Now, our office doesn't handle expungements because we don't frankly have the budget for that, and that's not why we're here today. But we were able to find an attorney to help this gentleman pro bono to explore expungement, which turned out to, for the reasons Marilyn mentioned, be an extensive process to get him the order that he needed. In the meantime, he had a difficult time accessing employment. One of the alternate jurors actually like gave him a card and was like, I'd be happy to give this man a job if I could, because after hearing the facts of this case, I know that he didn't do anything wrong. But that is almost never the case. Nobody looks at an arrest record and gets the whole story. And so this man, fortunately, was eventually able to get his expungement. He was able to get a job, and we never saw him again, which I think is the true testament. That's always a huge win for us. Another story that I want to share comes out of our Veterans Treatment Court. There have recently been the potential for individuals who successfully complete those treatment courts to apply for expungement right away. And there's apparently, by all accounts, been an increase in people doing that. One such individual was obviously a veteran. He was experiencing some trauma-related psychosis, and after being discharged from the hospital, wandered into someone's home thinking that that's where his wife was. Obviously, very confused, scared a lot of people. When he received treatment and realized after the fact what he'd done, he was horrified and embarrassed and felt so incredibly guilty about, scaring these people he didn't know. But he successfully completed the treatment program. He paid all his fines, his fees, and he was able to find a job and work to do that. But he wasn't able to secure a job in his field because of this like lingering legal issue. Once he was discharged from the Veterans Treatment Court, he immediately applied for expungement, had it granted, and was able to go back to work as an engineer. And by all accounts, is doing incredibly well. And those are the stories that I have. And I think when talking with everyone about this, we realize that the people who get their records expunged, and we see them come up on the case docket, like information sheets, they don't come back. We don't see them again, whether it's because they have increased their earning income potential that Marilyn said by 23%. And so they don't need us, or they're not finding themselves in the criminal justice system again. Like, it really does make a huge difference in the lives of the people who we would typically represent. And for those reasons, we strongly support this bill and would ask you to do the same. And I would also be happy to stand for questions whenever everybody's ready.
Thank you. Ross Stewart.
Hey, can you hear me?
Oh, I forgot. Yes, we can hear you. I forgot you were on WebEx though. There we go.
Sorry, I was unable to come in person today. But thank you for having me, Mr. Chair, and thank you, committee, for hearing from me. I was there last year as well to testify in favor of this bill. I'm happy to see that it is back again this year. I am a solo practitioner in Kansas City, and I do expungements for clients, and I do criminal cases for clients. And seeing a bill come through that will provide an automatic opportunity for my clients to either have not guilty verdicts given to them, acquittals for other reasons, or they get done with the diversion, they do what they're supposed to, and they get out of the system, having those cases get closed out in an efficient way that doesn't cost, 2 hours of billable time at a minimum, plus $195 filing fee for a district court, is really good for the people that I represent and the people that live in the state or the people that come into contact with the justice system in the state. So I'm in full favor of this. I know it's going to cut down on my work, and I'm fully in favor of that. I would rather have less of these to do if they can get put through, because like other people have testified today, my clients who get these don't get second time, hot charges. They don't get another battery case and call me later. Usually they are done with this portion of their life and they just want to move on and have the opportunity to go on new endeavors, but these things hold them back. The criminal history record keeps my clients from being able to get housing, keeps them from being able to get loans, keeps them from being able to go to school sometimes, depending on how many different cases or charges they have from their history from their youth. And so providing this is a great service to them to be able to be better citizens in the state. So thank you. Thanks for your time.
Thank you. Next, we have Adam Timmerman.
Good morning or afternoon. I don't even know what day it is anymore. My name is Adam Timmerman. I'm with the Greater Kansas City Chamber of Commerce. I believe our organization last year supported the legislation, and we are proud to do so again. The Chamber has long supported policies that have encouraged returning citizens and other justice-involved individuals to gain meaningful employment after serving his or her sentence. We all have heard the workforce problem facing our communities, our region, and our employers, and we believe that we at the Chamber believe that there is a large untapped talent pool of workers who are either returning citizens or individual with a criminal record. This is why the Chamber a few years ago started its Workforce Opportunities for Returning Citizens Initiative, otherwise known as WORK. The WORK initiative is aimed at getting returning citizens and other justice-involved individuals employed with stable, good-paying jobs, which include with our members. As part of this initiative, we actually have a long-serving relationship with the state of Kansas and other statewide organizations. And last year, we were able to partner with the Department of Corrections and Commerce to start a career campus at the Lansing Correctional Facility to expand employment, education, and reentry programming inside the prison with the increased of likelihood of success after release. So the Chamber believes that these initiatives are one of the components to address the workforce issues that so many of our employers are facing in our region. There have been 84,000 job postings in the last 12 months. We have an unemployment rate below 3%. And so again, tapping into this workforce, into this talent pool can really address those workforce issues that our employers are facing. And that's why we believe initiatives like this bill are part of the solution to the workforce problems. But these initiatives don't work if our returning citizens continue to face barriers to employment. The fruits of this hard work, the partnerships we have with the state, the partnership we have with the state of Kansas to get people back to work, they don't work if there's these continual barriers that prevent someone from getting hired. And so we have worked many years with our employers to promote ban the box when applicable to our employers and to have those circumstances be addressed. But we understand that that is not a solution for all of our employers, and this is where expungement can come in and really be an opportunity to expand the opportunities for returning citizens. We have heard firsthand stories from individuals with criminal records that are perfectly qualified and capable of working a job that just can't get past a background check for the very reasons of expungement that are addressed in this bill. And again, when we have 84,000 unfilled jobs in our region, that we have these background checks that are limiting the ability for these people who are qualified to work in these jobs that is preventing them from doing so. It really hampers our ability to address the workforce issue. So we recognize that not all crimes should be eligible for expungement, and we recognize that law enforcement should be able to look back at prior offenses. But we support the concept of automatic expungement. We believe that this is part of an overall workforce solution to address our workforce needs. We also have studies, and it's been noted that having a job has been shown to reduce recidivism, and individuals are less likely to recommit crimes when they have stable full-time employment. I heard a study once that someone who has gotten a job after their term has been served is less likely to go back to prison than an individual who's never been to prison is likely to go to prison for the first time. So these are good, stable opportunities that address recidivism, they address workforce. And that's why the Chamber has strongly supports 2028. And we look forward to working with stakeholders and everybody in this room. And as the previous people have mentioned, I'm happy to take questions at the end. Thank you.
Thank you. Todd Thompson, and Todd is on WebEx.
Chairman, representatives, appreciate the opportunity to speak. I speak on behalf of the Kansas County and District Attorneys Association. I am the current chair of their legislative session, as well as former president of the association. We also agree and understand the importance and need for expungements among people. The benefits that not only does it do for them for work, for opportunities with education, and also for opportunities for schooling. We only had one, and it is kind of a bigger issue for us, and it just what I think it's a minor fix with the legislation is it not only does it say acquittals, but it says dismissals with or without prejudice. Without prejudice, if you don't already know, basically means a case that's dismissed but is allowed to be refiled. I will tell you, and there's testimony from Brandon Jones from Franklin County and pretty much almost any other county. I particularly have a judge that does not really want to grant continuances, and sometimes cases last a little longer, so they will have to be dismissed, and we will have to refile those cases. This dismissal without prejudice adds a linchpin to us to having to not only refile but file another motion. I think if the language of without prejudice is, or the without and just allow the with prejudice is lasted, we wouldn't have any issues. But I can tell you that it will add a lot of extra work and headache and just for one little thing. And the without prejudice basically is just meaning that they're not not guilty or acquitted. It's just there might be a thing that we might have to go back to the well and file. And so that part is very important for us. But the utility and the easeability for cases that have been acquitted or dismissed, they honestly they should have their records expunged, because that's indicative that that they were exonerated of their crime, or the judge does not allow us to go forward on a case on those facts ever again. So there's no reason that should last in the record beyond what the statute has allowed for law enforcement, gaming commission, and such to look at. Again, I stand for any other questions as well. Thank you.
Thank you. Next, we have Mark Dupree.
Thank you, Sir Chairman, and everyone else. We appreciate the opportunity to speak. I stand with my dear colleagues. I want to just tell you who I am. I'm the District Attorney of Wyandotte County, Kansas City, Kansas. Likewise, I'm a former public defender and former criminal defense lawyer. I'm also a father and a Pentecostal pastor. And so today I will do my part in trying to make sure I maintain the speech and not give you a sermon. Though I do not see a time limit up here, and that's a little risky, but I'll be brief. I think it's important that you get the basics. And as a prosecutor, what's extremely important for us is making sure that every voice is heard. And the question came up earlier: what is or who is a victim? And I want to start off by stating that in this automatic expungement process, the victims are being heard. It's the prosecutor's job to make sure that their voices are heard, whether or not it was a dismissal, was an acquittal, rather it was a diversion. And a diversion, for those who may not know, is simply a contract between the defendant and the prosecutor's office that says, if you do what needs to be done and you stay out of trouble for X amount of time, then the case will be dismissed. You take whatever classes, you do whatever you need to do, showing us that, yes, that was indeed a mistake that you made and you're trying to move on with your life. And even in that process, the prosecutor talks with those victims and makes sure that they're okay with it and they're on board. And so I want to make sure that we know that the victim's voice is being heard. And even if it's not an automatic expungement, and we go on to what the statute says now, and it's a normal process of expungement, and you have to file it with the court. The prosecutor still has that role, and that role is to make sure that we talk to the victims and see what their desires are. Now, the second part I want to hit on is confusion. Confusion is a word that I want to make sure that you understand. As not only as a former defense lawyer, but as a prosecutor, I have had quite a few opportunities to deal with confusion. But as someone stated earlier, allow me to tell you one of my personal stories as I go out into the community often to make sure that they know what we do. And as a prosecutor, that we're for them. I recall going into a community event. It was about 100 people there. And as I'm there, I look up and this young lady who was in her mid 30s is approaching me. And she has about 2 kids running behind her. And she's approaching pretty fast. And, you know, as a prosecutor, I've done a lot of things. And so you never know what they're running at you for. So I step back and I say, hey, can I help you? And she says, Mr. Dupree. I said, yes, that's me. She says, can I take a picture with you? I said, if that's all you want, yes. And so we took a selfie together. And then when we were done taking the selfie, she explained to me who she was. And this young lady had been prosecuted in my office. You see, about 4 years earlier, she was a single mom with those 2 kids, and she was in a domestic violence situation, and she turned to help. And she had burned so many bridges that she couldn't get any help, and so she turned to drugs while she maintained this relationship while trying to hold on to her kids. And finally, my office ended up filing charges on her for drug possession. And not only did we file charges of drug possession, but the prosecutor's job also is to deal with children who are neglected and abused. So we filed a case to take the children out of the home. And we did that. But what happened next is the good part. Is that Mr. Dupree, not only was I able to get help through the probation and the programming that I had when I had the conviction, but I got stable and I got treatment, and then I was able to go through the process and regain custody of my children. And then, Mr. Dupree, you had what's called an expungement fair. If you want to hear about it, just read my written statement. But over 500 people came to meet us at the Kansas City, Kansas Community College, as we've been doing for the last going on 4 years, where individuals who didn't have the money and didn't know how to do the expungement came to me and said, I want to get this expunged off of my record. And having met all of the criteria and the time frame and hadn't received any more criminal record on her, we were able to assist her for free. And through a grant from the Kansas Legal Services, paying that $195 court cost, she was able to petition the court to get that expunged off of her record. And so when she ran up to me all these years later, she was saying, Mr. Dupree, it's off of my record and I have a job and I want to volunteer for your next expungement fair to help you. So here's what I want to say as I close, that this helps people. This helps people in their everyday practical life. She got her children back. She got a job. She was able to help not just her family, but help this community. And when people have their own money in their own pocket, they're less likely to try to take anyone else's. Victims are heard, community is blessed, and lives are changed. That's why you should support this bill.
Stacy Knoll. You get to I heard rumors that no one wanted to follow him. I'm sorry. I should have had him last.
Hello. I am Stacy Nell, and I'm the Executive Director of the African American Affairs Commission. There was some confusion on my part. I am a proponent of this bill. I'm not an opponent. I was opposing House Bill 2058 and supporting 2028, and I just got confused. Yes, I get to go after Mark Dupree. Thank you for that. Maybe I should just sing a song and say I'm the choir and get on with it. There's nothing that I can say right now that you have not already heard. We've talked a lot about the economic arguments for this. We've talked a lot about how this will actually help people, and that's where I want to stand. This is a bill that should pass, and we are definitely in support of this bill. As representing the African American population of Kansas, we know that we are often overrepresented in the criminal justice system. So having the opportunity to have records expunged was something that we are definitely in support of. One thing I would like to bring up, it's been mentioned a couple times, is fines and fees. As a commission, some of our legislative priorities have circled around trying to reduce or eliminate unnecessary fines and fees. As we know, sometimes people don't have the resources and the means to come up with the money in order to pay for fines and fees, and that can oftentimes trap people in the criminal system who, as we now have heard several stories, really can get out. So I would like to just put that caveat out there. To see about the reduction of the fines and fees, even if it's from $10 to $195, that could definitely be an undue burden on some people to have their records expunged. So I'm just gonna get off the stage here. Just remember everything that he said. I was not involved in this bill hearing last year. So this is my first year being involved in this particular struggle to have this addressed. So I really hope that you would work the bill, and then we can make sure that it gets to the floor for a vote and above the line as we are. Thank you very much.
Thank you. Wesley McCain. I gave you a little buffer between you.
I was thinking the same.
And she did a great job.
She did a wonderful job. Yes. Thank you, Stacy. My name is Wesley McCain. I serve with the Wyandotte County Health Department. I was involved in the hearings last session, and was involved in the hearings the session before that, or the year before that. I work in a public health department. You might wonder, why is someone from a public health department in the Judiciary Committee? This bill, the reason that our health department got involved with this bill is because it helps people get jobs. Maryland has cited some of the stats on that. There's been studies in Michigan and New York about the improvements in income that people get after they get expunged. You can't live a healthy life if you don't have enough household income. That's something that a lot of data has shown us. And that's how we got involved in this in Wyandotte County. Got a partnership with the Economic Development Council, led us into this work looking at, we know people not being able to access living wage jobs is a really important reason why people are not as healthy in Wyandotte County as they should be. Let's look at all the barriers out there. And presence of a criminal history was one of those barriers. And so, and I'll just say, and I'm going to make 2 points. The first point is what I just said. It really helps household income. And I'll make kind of 2, I think, important things to note is I don't have the stats for Kansas or Wyandotte County, but I know that in the United States, 77 million people have a criminal record. So that's 1/3 of adults. And so this is not a small number of people in Kansas that this bill is working to help. The second thing, which I think Marilyn also mentioned, but I'd like to say again, is really the reason why we're here, is expungements are really great, but there's only 5%, 6%, 7% of people who are eligible for this who actually go through the process to get it expunged. As a public health person, we look at groups of people, right? We look at populations. And so when we see a system and a process which is really beneficial, but which only a small number of people are taking advantage of, we see a system that can be improved. And because of the technology changes that have happened, I think there's 6 states who have passed kind of the full package of Clean Slate. What's really driving this is that when the expungement system was set up, we did not have the technology in place to be able to automate any part of the process, right? The person had to come, had to do the paperwork. And now that we have databases, centralized court case management systems, that is possible. So I think of this as both something that's good for people, but also a government efficiency item, which I think is really a helpful part of it. And then, so that's first point. Second point is this bill comes at a very good time. So as most or all of you know, the state of Kansas is rolling out a new centralized case management software for its district courts. I know the district attorney knows all about that, along with others here in the room. So that means that has a public access portal, which means that a record which you used to have to go to a district courthouse and ask by name, you can now search online. And so I'll use our highest state paid employee as an example, Bill Self. I looked up Bill Self this morning. He got a speeding ticket in 2007 in Franklin County. And I will say that has not gotten in the way of him accessing living wage employment at all. He's doing pretty well for himself. But people who are in more economically and socially vulnerable circumstances might have a different time with that. And I'd say as we roll this out, this bill is only dealing with non-convictions. That's a really important part. We're really starting this at a place where, people who have not been convicted, as this website and the search portal is coming online, I think it makes a lot of sense for those people not to have all of their arrest histories and all of those things put out there for everyone. And I think that it's really great timing, and I really appreciate the opportunity to speak and the fact that you all are considering this bill. So thank you.
Thank you. Committee, you have written proponent testimony from Jermaine Wilson, and you recently got some sent to you from Eileen Berquist. Anyone else here as a proponent that wants to speak? Okay, let's do questions. Representative Lewis.
Bob Lewis from Finney County. I wanted to ask the fellow who appeared by WebEx, the DA, Representative DAs, is he still available?
Yeah, Todd, are you still out there?
I'm here.
Hi, thanks for your testimony. I understand that you're proposing an amendment to the bill which would take out the without prejudice. Is that right?
That's correct.
Yeah. Okay. So consider this hypothetical and tell me how that would work. I understand that most of the time when you, at least some or most of the time when you dismiss without prejudice, you do so with the intention of refiling. But sometimes you may have that intention when you dismiss without prejudice, but then for whatever reason, the case never gets refiled. And so how would that work if we took that out? Somebody would have had a case dismissed without prejudice, but never actually had to face charges again. And they'd still have that on their record.
They could.
That's sort of troubling.
One of the things you could probably look at doing if you want to add a mechanism for that to muddy up the statute a little bit more, but make it more beneficial, is once it's past its statute of limitations, that it would also be expunged.
Yeah, that would make sense to me. Thank you.
Representative Carmichael.
Thank you, Mr. Chairman. Mr. Thompson, stay close at hand.
I'm right here.
All right. Following up on Representative Lewis's excellent question, though, why should this person who's never been convicted of anything, who's had charges filed that failed for whatever reason, why should they be held in limbo waiting for a statute of limitations to expire? Wouldn't it be a lot simpler? Because I don't even know how you key that. You'd have to determine what the statute of limitations is for every case, somehow key it into the computer at the time you enter a dismissal without prejudice. And then I guess the computer clock ticks off 6 years, and then all of a sudden it comes out. Wouldn't it be a lot easier that if you dismiss with the intention of refiling, that you simply file your motion at the same time to say, Judge, the reason we're dismissing this case is we can't meet the deadline that you have for trial. This person's guilty. Don't expunge this dismissal. Or conversely, Even if you dismiss with prejudice and it's been expunged, I don't think that prevents you from refiling the charges. It just means that that initial case number is no longer in the record. What am I missing?
If it's dismissed with prejudice, you can't refile it.
I clearly understand that. I must have misspoken.
Okay,
I'm
yeah,
talking
the
solely
last
about
part.
dismissal. I'm sorry, sir. I'm talking solely about dismissals without prejudice. If I said
Okay.
otherwise, that was my error.
Okay, I'm sorry. That last part you kind of switched. There is clearly a mechanism for that. I can tell you oftentimes, we do global resolutions oftentimes that the person is not actually, well, how's this? We make an agreement to dismiss some cases based on an agreement to plead the other cases that we might still be able to prove. Does that warrant them to get expunged at some point in time? Sure. And it would be possible to just file it at instantaneous. It's just an added extra work, and I can tell you that generally when the case is dismissed without prejudice, in my experience, it is a case that we are actually looking at refiling, and generally when the defense wants it or knows that we cannot refile it, they'll ask for it to be dismissed with prejudice. And so that's also a request that the defense can make at the time of the dismissal to start that mechanism that you're asking to have done.
If I may, Mr. Chair. Well, then perhaps a better way for us to deal with these dismissals without prejudice, because you're intending to refile, you're just dealing with a court that wouldn't give you a continuance, or you can't find the evidence, or you can't find the witness, or whatever reason. Why don't we just change the dismissal without prejudice statute to say that a dismissal without prejudice turns into a dismissal with prejudice if you haven't refiled within 6 months and or come to court to show good cause? Would that solve your problem?
I don't know that it would solve my problem. Within 6 months or you're adding extra mechanisms that I don't think are exactly necessary to accomplish the mission that you have. Any party could probably request to have it dismissed with prejudice at the time of the hearing. And if the prosecutor so decides that, yeah, this is a case that we're not going to refile, we don't object. I've done that multiple times. I don't know why that isn't something that could just happen and it would trigger this bill immediately.
Finally, Mr. Chairman, Mr. Thompson, could we at least agree that the defendant, unless and until convicted, is cloaked with the presumption of innocence, and accordingly they should not be paying any penalty under the law unless and until convicted, including having a record that impedes their ability to get a job? Could we agree with that philosophy or principle?
It's the principle I live by with every single one of my cases. And in fact, I've put on multiple different expungement days, and I think I was the second in the state to do so. We very much believe that this law has a lot of good and utility for people, and very much we would like to get people back on track, whether it was an errant filing or some other cause. The only issue we have is when there's a potential of refiling, and often that's a case when they're dismissed without prejudice, that this bill would not apply. I think that's not really a hard request to make.
Thank you, Mr. Chairman. It seems clear to me that the bill has the provision he needs, and that's all he has to do is, when he files the dismissal without prejudice, file the motion not to have it expunged, and the problem's taken care of. Thank you, Mr. Chair.
Additional questions? Representative Curtis.
Thank you, Mr. Chairman. And first of all, as most of the committee members that have returned know that I've been working with this coalition. It started out as a bipartisan bill in this committee with a couple of reps who are no longer serving on this committee. And so through a 3-year process, we finally got to this point where The Judicial Council had studied it, had made recommendations, and that is what this bill is based on. And many of the people that you heard testifying, I just want to say thank you very much, because they have stuck with this for a good 3, almost 4 years now, and have made a lot of headway in trying to address any of the issues that have come up. Marilyn Harp, who we heard from at the very first, if I could just ask her, she served on the Judicial Council that looked at this. And so I'm thinking maybe you may have some insight, Marilyn, into this line of discussion that we're having about the dismissals without prejudice, if you could respond.
Thank you. Remember, committee, that we're trying to find a computer sensitive system, and the computer does not know if the dismissal was with or without prejudice. That is in the record, but it's not a checkbox. So any kind of distinction like that means that the computer cannot initiate this process. The computer knows the case was dismissed, not that finer point, which is why through negotiation we got to that point.
You have another question? Okay, so Representative Mon, then back to Representative Lewis.
Thank you, Mr. Chairman. Marilyn, could you come back up real quick? So my question has to do with the other side, with the dismissed with prejudice. And there are obviously some courts of concurrent jurisdiction, city and county courts. If something is dismissed in city court with prejudice and therefore immediately expunged, the records are no longer available. And as we know, with many people, record keeping is not their forte. And so maybe the defendant no longer has access to the records. Is there anything to prevent the opposite of happening? So now the district court refiles on a case that has now been dismissed with prejudice and expunged. Do you foresee any? I mean, I know these are just would be unlikely, but these are the possible unintended consequences of something like this, where the records are no longer readily available and institutional memory doesn't quite cross over between municipal and district courts.
So the first of all, this bill doesn't cover municipal, so it might be the opposite, right? The district court dismisses and then the municipal wants to file and a defendant wants to go in and show they were dismissed. So what we're talking about is public access to the records, because the access to records by law enforcement, courts for sentencing purposes, the KBI, law enforcement, the Lottery Commission, all those folks can still see this stuff as has been set out in expungement law forever. We're talking about public access. And I'm kind of, the last time we were talking about what you could see, everybody in our little group jumped on their phone to go look at that public portal, because you can see every case that's been filed with or without an outcome on there. And a defendant will always have access in person to their records. It just won't be on the public portal, which is really what this part of the bill's about. Public access to that stuff.
Just to follow up, why would this not apply to municipal courts?
Their expungement law is in a separate part of Kansas statutes. And so this part only applies to district court. There's a separate municipal court part. And because of the automated process of there, and we don't want to presume to require of municipal courts any kind of automated process, we have not proposed to make these changes there.
Representative Lewis.
Yes, if you could, just to follow up, you said that the computer didn't know the difference between with and without prejudice. Is that right?
That is my belief in this process.
I guess why can't that be reprogrammed?
there's the possibility of that. Through this long process, we came to we came to a process that let the prosecutors say stop, filing a piece of paper to say stop, and even asking for a hearing if they want to, and thought that was on balance the better solution than requiring the entire full court system to be reprogrammed. I mean, one of the interesting things is that means somebody else has to spend a lot of time checking a box, which way or not, in the court system, rather than the prosecutors in those cases where they want it. I mean, this whole thing is about trying to keep prosecutors from having to file an extra piece of paper. And to solve that problem, we're adding a box in every case for dismissals to be filed. And just, I mean, in all of these, there's a balancing, and that was the balance. That was the decision.
Representative Titus.
Thank you, Mr. Chairman. I think this one will be for Mr. Thompson. Just to go back to the idea of the prejudiced and without prejudice, it seems to me there's the opportunity at the point of the dismissal, if any prosecutor files an objection, simple objection we plan to refile pretty much covers this from going into the automatic expungement. Am I misunderstanding the process or the key points here? But it seems like there's no rule you have to wait a certain amount of time that you could enter this right away. But I just want to make sure I'm understanding it.
It does appear by the reading of it that you have 30 days within to file it looks like it's right, file a written motion for the court to review, and then a hearing regarding whether to allow for the expungement or not. So it just adds an extra hurdle, maybe even extra hearing, maybe extra cost when you do it that way. I imagine that you can maybe make a oral motion. I don't know why there couldn't just be a catalog on the computer or whatever. I'm not the one that's savvy that just extracts the without prejudice, but again, it's the one kind of major issue that we could. But I assume there could be a point where you say on record we're looking at refiling, and hopefully you can take it up. But I hate to give just a discretion on that. And have to have a hearing regards of it and what we have to do. It really would cause some extra headaches.
Representative Curtis.
Thank you, Mr. Chairman. Appreciate the second chance here. Since we have a district attorney here, if DA Mark Dupree would please just, we had to have a starting point, and you definitely have been in the weeds with us on this issue. So we definitely had to have a starting point. The point is to make it a streamlined process. Could you give some insight into the discussion that we're having about the dismissals with or without prejudice?
Yes, I can. And I tell you that through these years of coming up here specifically concerning this bill, I tend to find myself constantly on the other side of my dear colleague on the screen. But I am happy to state that this is the closest that me and my dear colleague have been on this issue. So I think we are getting somewhere. I do think that it's important to note that when we're dealing with the process, right, that part that I said, confusion earlier, at the end of the day, the folks who are trying to get their records expunged are the ones who don't know the process. They're the ones who are confused. They're the ones who don't know where to go, where to file, who to talk to. They don't know the difference between dismissal with prejudice versus a dismissal without prejudice. And ultimately, you're correct. Unless the state proves beyond a reasonable doubt that this person committed this crime, they are cloaked with that one thing, and that is called innocence. And so if the DA's office objects, then there's something that we can do there. We make it known, and then there's a hearing. Just like right now, without this bill going forward, if a person files for an expungement, the DA is notified, and we can let the court know we object. And so in essence, we're not adding anything new to this process. We're simply saying, hey, just pay attention, as most and all of us state and district attorneys and county attorneys do. Todd, I want you to hear me. I'm saying that all of us pay attention. And so with that, if someone wants to file for an expungement, our office can say we object. If it goes through the automatic expungement, our office can say we object, and nothing changes. So I don't see this putting more work on us. I don't see this costing more, but in essence, it guarantees that that person who is affected by this, who was found not guilty, who was in fact acquitted, will have that opportunity to still move forward with their life. And so, but again, we're closer than we were, but I don't see this as something that should stop the process or something that we should have to delay this process from moving forward.
Any other questions for the proponents? Okay, well, let's move on to neutral conferees. Sean's falling asleep back there. Hey, look at that.
Yeah, but I'm neutral. Is this still on? No, I truly am. Good afternoon, Mr. Chair, members of the committee. I'm Sean Jurgensen with the Judicial Branch. I'm appearing neutrally today to request the committee to consider an amendment to the bill that would extend the implementation date from July 1 of 2023 to July 1 of 2024. Because of the mechanics of how this will work on the ground, it kind of dovetails from Representative Lewis' comments earlier. Because of the number of criminal cases that this bill could impact in the district courts, entry of the order has to be automated for this to work. And so to give, currently, as one of the previous conferees mentioned, we're currently in the process of rolling out a new case management system in the Judicial Branch. And may it happen soon that it is finished. But currently, 100 of our 105 cases are currently on the new case management system. The 5 that are left, though, are 5 urban courts, and that still represents a pretty good chunk of our overall caseload. And so extending the implementation date would give us the following year to get the balance of our courts on this same platform. And secondly, it gives the software company time to write the code to implement the automation of this process. And so that's what it would do, those 2 prongs, by extending it by 1 calendar year. I've already visited with Representative Curtis, the sponsor of the bill. They're agreeable to the change. They view this as a friendly amendment. So it's my hope that the balance of the committee similarly would view it as a friendly amendment. And it would be my hope, Mr. Chair, that I would work with Representative Curtis in your office to craft a balloon for the time in which the committee may consider this bill.
Got any questions for Sean? Representative Mon.
Thank you, Mr. Chairman. Sean, would we be able to solve this problem by just delaying the implementation of the automated part and still be able to get the immediate expungement if filed by the defendant's attorney or by the defendant themselves through the regular electronic filing system? So we still have that same expedited process, but just not the automated side of it. Is that?
If you mean in the first section, shifting the requirement to enter the order or upload the order of expungement onto the district attorney's office from, is that what you're suggesting?
Yeah, I don't actually have the full bill in front of me, but basically I'm suggesting that maybe if we, rather than it just be the automated process, but that the defendant has the right to immediately seek expungement rather than waiting the
2 years,
the time period,
reach 23 or whatever it is.
With that kind of,
yeah, I mean, for the court system, because if memory serves me right, I believe that in FY22 there were over 8,300 cases that were terminated by dismissal, if you will. And so when it comes to that degree of volume, for us to track it just on the ground, it would have to be automated for us. But yeah, certainly if there's an amendment to that effect, we'd love to see it, and I can tell you how it would impact us.
Yeah, I just, I get where you're coming from, and I agree that probably the time frame is a little ambitious. But say, if I was representing a client and the case gets dismissed, just allowing me as counsel to automatically file an order of expungement and without the waiting period.
To just petition the court for an order of expungement then? Yeah, fair.
All right, thank you. Any other questions for Sean? Okay, thank you, Sean.
Thank you.
We also have written neutral testimony from the league, and who's Laura's on behalf of? Laura, is that Judicial Council? Yeah, from the Judicial Council. Any other neutrals? Okay, anyone opposed? Right. And Natalie has one more thing before I close the hearing.
Thank you, Mr. Chairman. During my bill brief, you might have seen Sean quivering with nervousness in the audience. He kindly pointed out to me that I made a mistake in my brief. I referenced a portion of the bill that would require the KBI to forward that order to the courts, and they would amend the appellate court decisions on their website to remove the defendant's name. That provision was in the bill last year. You guys made an amendment to take it out of there, and it is not in this year's bill, but I did talk about that. So I wanted to point out that mistake in my brief.
Very good. Okay, I'm going to close the hearing on House Bill 2028. Thank you all for coming. Committee, we're going to try to work a bill or two or three, or we'll see where we get. 2015 is the first one. So for new people who have maybe not worked a bill anywhere before, we'll have Natalie start off. She'll give us a very brief overview of what 2015 is, and then we will entertain any amendments, and then we'll see what the committee wants to do with the bill itself. So, Natalie.
Thank you, Mr. Chairman. House Bill 2015 would authorize the designee of an employing agency or entity to petition the court for infectious disease testing in certain circumstances.
Questions for Natalie? Are there any amendments? Seeing any, let's see what happens without Representative Hoheisel on this committee. I know I was just getting ready to look your way, Representative Lewis. Can you make a motion for everything? Okay, he's probably watching, wondering what I'm going to do. Okay, what's the pleasure of the committee on House Bill 2015? Representative Carmichael.
Thank you, Mr. Chairman. I move that our committee report out HB 2015 favorably for passage.
Is there a second? Second by Representative Titus. Any discussion? Close.
Thank you, Mr. Chairman. I close and renew my motion.
For the motion, all in favor say aye. Aye. All opposed say no. Motion carries. Oh, yes. Recording of votes. Representative Carmichael, Representative Heiberger are both yeses. Now let's look at House Bill 2016.
Mr. Chairman, House Bill 2016 clarifies how property held under a transfer on death deed is distributed when one of those beneficiaries predeceases the grantor.
Any questions for Natalie? Any amendments? Is there a motion concerning House Bill 2016? Representative Curtis.
Thank you, Mr. Chair. I move that the House passes out House Bill 2016 favorably.
Is there a second? Representative Heiberger. Any discussion? Seeing none, Representative Curtis, you may close.
Oops, I closed and I should have said, I recommend the committee passes out. Thank you.
Okay,
I close.
Heard the motion. All in favor say aye. All opposed say no. Motion carries. Affirmative votes, Carmichael, Heiberger. Let's look at 2017.
Mr. Chairman, House Bill 2017 enacts the Uniform Family Law Arbitration Act.
Anyone have questions? Are there any amendments? Is there a motion concerning House Bill 2017? We're going to pass this. I've got a Heiberger. Representative Heiberger.
Mr. Chair, I recommend the committee, I move that the committee recommend House Bill 2017 favorably for passage.
Is there a second? Representative Vaughn. Any discussion? Seeing none, Representative Heiberger, you may close.
I close and move my motion.
With the motion, all in favor say aye. Aye. All opposed say no. Motion carries. Kathy, Affirmative votes from Carmichael and Heiberger. The last one I think we'll get to today is House Bill 2018.
Mr. Chairman, House Bill 2018 permits a will or a copy of a will filed within 6 months after the death of the testator to be admitted to probate at any time.
Any questions? Any amendments? Is there a motion concerning House Bill 2018? Representative Heiberger.
At the risk of being too Hoheisel-esque, I move that the committee recommend HB 2018 favorably for passage.
There a second? Representative Humphreys. Discussion? None. Representative Heiberger, you may close.
I close and move my motion.
You've heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. Yes votes Carmichael, Heiberger. Very good. That's it, committee. Way to go. It will not be this easy all session long for the new people. We generally get along fine, but sometimes we argue and debate and certainly try to fix issues that come before us. So that's it. We're adjourned and no meeting tomorrow, despite the fact it does say we may meet to work bills. We're not going to. So no meeting tomorrow. No meeting tomorrow. Yeah.
My wife wasn't expecting me